Welcome everyone to a virtual Legal Hackers New Zealand event that we're running here on the discussion, just broadly a discussion on the decision of Ruscoe and Malcolm versus Cryptopia. Thank you for joining us. I just thought your host and event moderator, Robert O'Brien, I'm one of the co-organisers of Legal Hackers. And I just thought before we get started, we'll just go through a few little housekeeping and introduction sort of things that's going on. First of all, just a brief introduction to Legal Hackers itself. So Legal Hackers is a global movement that's organised as a bunch of local community-orientated chapters around the world. It's intended to basically be made up of lawyers, policymakers, designers and technologists like myself and academics, with the purpose of basically exploring and understanding and developing solutions around various issues that intersect law and technology. And what we try to do is actually to be quite low-key in what we do. We work through either events like this or hackathons and physical meetups, etc. But given the current situation, virtual one seemed quite appropriate on that time at this point in time. If you wanted to find out more, I presume most of you have come through via the Legal Hackers New Zealand group on meetup.com, but there's a URL if you need to do that. The essential outline that we'll be following today is we'll just go through with an introduction to the panelists. I'll give a little case background and just basically a summary for those that haven't really been that familiar with it. And I'll also get the panelists to give their perspective on the case overall, just a short perspective on that. And then we'll jump into the discussion itself. We'll focus mostly on digital assets and property, since that is the core essence of this decision. And then we'll go into how that then applies into the trust situation and indeed the Companies Act and insolvency. The latter parts of this discussion will move into things around, is a smart contract a contract? Because this was mentioned in the decision, and there was a strong reference to one of the UK jurisdictional task force documents, which was a key part of the rationale or analysis for this decision. And then also I'd like to look at implications and further future use implications of digital assets, etc. going forward. First of all, I'd just like to briefly introduce our panelists. James Ten Edwards is from the Internet New Zealand policy team. I'll get each of the panelists, by the way, to do their own self-introduction. Rick Shearer, who is actually just running a bit late, so he will jump in when he can. He's a partner from Loden Jordan and is a commercial lawyer focusing on ICT law as well. Rochelle Furneaux is one of my co-conspirators, co-organisers for Legal Hackers. She's also a senior solicitor at ACC, but she's also been on the Council of Internet New Zealand and has largely been involved in a lot of technology-related and social enterprise type of things. David Harvey is a district court judge under an acting warrant at the moment, but was also wrote the book on internet law in New Zealand. And finally is myself, one of the co-organisers of Legal Hackers, and I'm not a lawyer. I'm a software engineer, but I happen to work in the intersection of technology and law. So with that, I'd just like each of the panelists to kind of self-introduce. I'll start with James, if you don't mind. And if you can just give yourself a little bit of a background and stuff on that side of things.
Okay, thanks, Robert. Kia ora koutou. So I'm currently on the policy team at Internet NZ, which I've been for just about 5 years. And the day job there is to understand and share insights about policy issues around the internet. And that's involved a lot of work on intellectual property policy over the past 5 years. So what should copyright be, implications of the Trans-Pacific Partnership when that was a thing, and then the comprehensive and progressive Trans-Pacific Partnership, and then issues around privacy, all sorts of things around where the possibilities of new technology hit the complexities of society and law.
Cool. Wondering now, Rick, if since you've joined in, would you like to give a quick introduction to yourself?
Yeah, thanks. Sorry for being a bit late there, connectivity problems. My name's Rick Shearer. I'm a partner at Lowndes Jordan, a law firm in Auckland. I am a internet digital business lawyer, so I deal with things from a range of things from privacy to cybersecurity to intellectual property to copyright and so on and so forth for a number of clients, both here and overseas.
Right. Now, Rochelle, would you like to give I'll just spotlight you, and if you'd like to give a little introduction.
Sure. I'm Rochelle Furno. I am currently, my day job is that I'm a technology lawyer at ACC in-house, and but I've been involved with technological issues for a number of years now, including being on the council at Internet New Zealand. Have had discussions with Robert about distributed computing systems for about 10 years now, and so have been very interested in the application of the law to some of those concepts, and working through some of that with our legal hackers hats on, very much as a side hustle, if you like, to my day job. Super interested in the trust side of the technical issues that relate to the trusts. So in my background, I was a litigator that worked as a junior lawyer on a lot of the cases that came out of the post-87 crash, and so there was a lot of trust-related issues, and I'm just finding that quite interesting to revisit that.
Thank you. David, I was wondering if you could now introduce yourself.
Sure, I'm David Harvey. Good afternoon, everybody. I am a district court judge with an acting warrant, which means that I'm retired from full-time work, but I can go back and do work pretty much when I want to, although recently there have been a few interferences with that particular program. I've also taught law and IT at Auckland University, and after my full-time work with the district court ended, I helped to set up a research centre at Auckland University focusing on ICT law. And I've written on law and IT, a textbook, and also a monograph, if you like, called Collisions in the Digital Paradigm. And one of the issues in collisions was that of digital property. And I have been critical of the way in which the courts have approached digital property. And I think finally, they're beginning to get a handle on it. So that's what we're going to be talking about today, I think. Over to you, Robert.
Thank you. Right, thanks a lot, everyone. So carry the theme here, just to introduce myself. Robert O'Brien. As I say, I'm a software engineer, largely working in distributed systems. My exposure to working in the computational law kind of area started in around 1993, where I led a team that was working on the implementation of the ACC claims processing components of the Act in Prologue, which goes back quite a way. But since then, I've been working in the financial markets and payments, usually wholesale back-end sort of things, and very much in the been interested in the cypherpunk and the financial cryptography space for nearly 25 years now. So I've got a fairly long history of understanding all the cryptocurrency sort of space, going way back before Bitcoin even existed. So with that, we'll try and get into basically the meat of this discussion that's going on. And what I thought I'd just do now is just give a sort of quick, for those not familiar with too much, just a quick case background to the Cryptopia situation, what was actually happening there, and what's ongoing. So Cryptopia itself was actually formed in 2014 as a cryptocurrency trading exchange. It was started basically as a hobby and then really kind of got quite a bit of traction, particularly around the sort of major hype sort of phase of 2017. But it started as this hobby and was eventually co-founded by Rob Dawson and Adam Clark, both software developers down in Christchurch at the time. As far as I understand, I don't think they had any background in trading systems or writing exchanges or anything else like that. So that was fairly typical of things like Mt. Gox and other sort of early exchanges. The quality of exchanges these days has increased significantly, but in the early days of around 2014 and so, that wasn't the case. In 2019, I think it was, there was a loss of 30 million New Zealand equivalent of the cryptocurrencies. I'm unclear personally exactly what happened, and as far as I'm aware, that's an ongoing criminal investigation. And there's sort of speculation around how the currencies or the cryptocurrencies were actually transferred out of Cryptopia. As far as I understand, most of what was taken was actually Bitcoin and Ether. And so that was effectively an unauthorized transfer of those cryptocurrencies to some notional undisclosed exchange. All right. The details are not clear, obviously, and are subject to an ongoing criminal investigation. As a result of that loss, Cryptopia was placed into liquidation in May 2019, shortly after the loss was actually identified. At the time of the decision, there's considered to be roughly about 170 million New Zealand dollars equivalent of approximately 900 cryptocurrencies made up of both the native coins like Bitcoin and Ethereum, but also a whole bunch of tokens, and that 900 number really is made up of what would be most likely ERC20 tokens. As a result of having an estimated 170 million, and admittedly that was before the Black Thursday of recently, where valuations of cryptocurrencies dived spectacularly. But the liquidators have essentially sought guidance from the court, the Christchurch High Court, over issues of just who owns the remaining cryptocurrency, and that is under the control of Cryptopia, and therefore what should happen to it after that. In particular, they've applied to the court under section 284 of the Companies Act, New Zealand Companies Act 1993. And they're looking to what to categorise and the distribution of the assets. That's what they're looking at. In order to answer that question, there was an additional factor of this: were those assets, if they are indeed assets, were they actually held under trust, which was the secondary question to this. And therefore, it's really a tussle between the creditors to Cryptopia and the account holders. So really quite pivotal to this decision is whether or not to classify all these cryptocurrencies of different forms as property or not. And that's where the bulk of the decision focuses on what's actually going on there. Now, with that, I would just like each of the panelists to give a sort of perspective of what they think is particularly interesting to them about this decision, both professionally and personally. And Rick, I might actually just start with you at the moment.
Thanks, Robert. Yeah, I mean, I have followed along this path along with the others on this call, in particular Judge Harvey and Rochelle and James, to around both formal and informal discussions about whether digital items, I'll call them items, can be classed as property. There have been various decisions around the periphery of that over the years, some of which have gone backwards and forwards, and in particular leading to the Dixon decision, which no doubt we'll get into discussion about. I've taken the view as somewhat of a pragmatic commercial lawyer in background with IT and IP laid over the top of that, that in a sense what has value is worth protecting, and property rights are probably the most convenient way, the most well-known legal way of accomplishing that. And therefore I was in a sense pleased when Dixon resulted in the Supremes with the result that digital file and the criminal regime could be property, notwithstanding the somewhat tortuous way in which that decision was arrived at. And then to see some of the other cases come through, and in particular I'm glad that there is mention of the .com litigation in some of the cases, because that somewhat obliquely also came up with the proposition and expanded the proposition from Dixon that digital files could be property in the criminal sense, and then that's transmogrified in some senses through copyright. And here we are in this environment, in the Companies Act, coming along the same way. What particularly pleases me though about this decision is the more rigorous analysis of what it means to have property in something and the way in which that's gone about. And I don't want to prejudge, if that's the right word, the discussion, but that's certainly to be welcomed.
Cool. Rochelle, I would be interested in if you can follow on from that and just give us a sense of why you think this decision is interesting personally and professionally.
I hope my internet holds up. It keeps telling me it's unstable. So yeah, I think the fact as to whether cryptocurrency was property or not was just super interesting from a pragmatic perspective, because when you think about what cryptocurrency is, it seems in many ways not to be what we consider to be property. And I think I'm with Rick in terms of looking at the value of cryptocurrency is the crux of this, the fact that it has value. I'm not sure that I would spread that value along with other data files, but cryptocurrency itself certainly has value in a way that it does need to be protected. From my perspective, the trust issues are also super interesting in terms of the impact that might have on future cryptocurrency transactions. So I've had to go back and remind myself of the implications that something could be held in trust and that the courts could determine an outcome that's different from what the code determines and the impact of that. So I think that's interesting and just pragmatic, and probably not super legally interesting, but from a pragmatic perspective, it is interesting how the courts might touch transactions.
Okay, thank you. David, I'll ask you for your comments now, if you could.
Sure. I think that Cryptopia is an important decision because it really analyzes in considerable depth, first the nature of cryptocurrencies, and then secondly locates cryptocurrencies within a property-based framework. There had been 4 other cases from various courts in the Commonwealth over the last few years that had basically assumed, if you like, without any deep analysis, that cryptocurrencies were property, and it sort of seemed to be a leap of faith. But what is important about the Cryptopia case is not only what it does for cryptocurrencies, but also its location within the wider development of property concepts within the digital space. And there's an earlier case that's referred to in Cryptopia called Henderson and Walker, which deals with other digital files and digital types of files. And the interest that I have is, as I suggested before, a rather casual approach that the courts, particularly in Dixon and following, have adopted towards assumptions that a digital file may be property without actually going into it in any depth. What has happened now, of course, with Cryptopia is that that deep analysis has taken place, and can we draw from that any conclusions generally about digital files and property? And my view is that there isn't a universal theory of property in the digital space yet. But what Cryptopia and Henderson and Walker do is that they provide us with an analytical path that we can look at other aspects of digital material, if you like, to determine whether or not it's property. So it has quite a wide range. It's good insofar as cryptocurrency is concerned. That's great, and I think that it'll be a leading case as far as other countries in the Commonwealth are concerned. And certainly a couple of days after I wrote a piece on digital property, Cryptopia was referred to in a case in Saskatchewan. So it's a case that's sort of beginning to spread, but it's very, very important because it deals specifically with cryptocurrencies in a very broad analysis. But I think that it actually has a wider implications, and we may be able to get onto that later on.
Thank you. And yeah, that is certainly the stuff that interests me. James, I wonder if you can now give your view from the policy perspective as much as your own personal view.
Sure. So I'm not burdened or privileged with resolving direct practical problems in the same way that Rick and Rochelle and David are in their day jobs of solving legal problems. So Rick emphasized he tries to take a pragmatic approach. That's where I land as well, but I also zooming out and taking a systems view. And so I think the decision is useful. That's one of the reasons that having the argument and reasoning here in Cryptopia is so helpful compared with the past cases. We've flagged that we might get onto Dixon. In the Dixon litigation, one of the parties was self-represented, and so didn't have there wasn't full argument from a lawyer on the ins and outs. And the digital stuff is really important, and the idea of property is a really important legal tool for solving problems, finding out who gets to make what choices. And we've kind of gestured that over the past couple of decades, there's been lots of exploration of how these things line up with each other. So it's helpful that we have in the context of cryptocurrencies something that works through that and speaks about the specific aspects of cryptocurrencies that might put them in the class of things that are property, and that it's done so in such a detailed way so that there's room to think about the complexity of other information assets and whether they have the same properties, whether the reasoning that applies to cryptocurrencies would also go there. So without expanding on it too much, I think this it's useful to put this in the context of intellectual property, where we have specific law on patents and copyright and trademarks, and at a very broad level, those take things that are very easy to share or copy or do. So you can do the same invention as someone else. You can share the story or content of someone else's book or movie. And they take these things that are otherwise easy to share and they put a property framework around them so people can engage in market transactions. And this is a bit different because it's not a statute that's doing the same thing, but it's sort of a broadly similar exercise of saying, when do we want the property toolkit to be available on things that would otherwise be easy to share? And I think that cryptocurrencies are kind of interesting because they use a whole lot of technology to try and carve out of what would otherwise be free-flowing bits and bytes something that has the character of being finite and tradable. So that's where I go with the comparison between intellectual property and cryptocurrency. And I think Cryptopia is very useful analysis of the things that are going to make that difference.
Excellent. Thank you all very much. I'll just sort of add my take on this as well. So obviously, I look at it through the lens of the sort of why I got into this sort of area was I became very interested in the use of data. A startup that I was a co-founder of out in London had started getting used by the intelligence community, and I was a little worried at the time. This was around all the dot-com bust and stuff like that. I was a little worried about the use of technology and what that meant. And that led me to think a lot more about ethics and privacy-related concerns, which in turn led me to think about digital identity and also the idea, well, how do we actually protect data about us? And the weird conclusion that I came to, long story short, was that money had a very important role to play in that. And so one of the key things here was, could we actually place contracts in a sense? Automated contracts in particular was what I was interested in, given my background, working in derivatives and other sort of areas where we were automating contracts. Could we apply the same thing to the use of data? And that's where I came from, the point of view, and then my involvement into what's the Data Commons of New Zealand project, which was really a framework, if you think about it, is actually a trust framework for the governance of reuse of data that we sort of started working on around 2014, 2015. And the essential element there was, in order to get responsible reuse of data, we actually had to turn that data into some finite packet, as James talked about, something that was uniquely identifiable, and then we could express the rights associated with the reuse of it. And obviously we were talking about integrating between machines, so not necessarily people. So we have to have a system which works at the speed of machines. And that effectively starts Landon looking at a lot of things like, what is a digital asset? So this decision for me was really important when I actually started reading through it, because I don't pay much attention to just the speculative cryptocurrency space at all. I'm far more interested in the much broader application of this to society, or as James referred to as the system things. So I was very interested in this decision from that what David is touching on is the universal definition of property in law. Because if we are to actually build a true proper data governance, or what I refer to as interpersonal data system, then we effectively need some that is sending data between, or packets of data between different systems owned and operated by others. Then we need the legal system to be able to help us out with that. So it's quite important that the legal system starts to understand what this technology is. And that motivation was actually a key reason why I'm a co-organizer of Legal Hackers, and why this decision with its key points and stuff like that is very important to me. Right, with that, I'll just move on to now sort of our discussions around digital assets specifically. And I'm gonna start this from from my perspective, having read the decision, and leaping off to where David actually concludes in his property revisited. What was it? Digital property revisited?
That's the one.
Yeah. Where he leaps off in terms of the conclusions and his personal, his position on side of things. I'll just fire this up for everyone to refer to. David finishes in his conclusions that, one, it's not the complete answer. It's not a universal authority for the principle that digital data is property or that digital files are property. The authority for the proposition that cryptocurrencies are property, with little difficulty, rationale could probably be extended to other aspects of the blockchain. So that's where I'm going to start, and we'll sort of work back from that, I think, in a way. One of the things that struck me within the decision was the tortuous route by which General tried to actually explain the nature of cryptocurrencies, in particular the private and public key pair. And what struck me within that was there's actually some technical inaccuracies in the description, but it doesn't detract from the decision. But it seemed to have pivot around this notion of a digital file versus the information in the file. So we can think about this, the data versus the content, or the data versus the information. That seems to be a key theme that's coming through, the information content, but from law's point of view, information can't be property. But also often a lot of the framing within the space starts from the top. It tries to explain how the system works at the top and then works backwards. I just want to quickly start from the bottom and start with the notion of a digital file, since that seems to be understood within law already. Databases seem to be understood in law, and indeed one of the case law that was referenced in the decision was about a database in particular. It was that UData. The first thing is that what a cryptocurrency, and I'm going to talk about Bitcoin here just as the general case, that most of the sort of blockchain-based systems in some way represent or have similar behavior. I know that's not true across the board, but for simplicity, we'll just stick with the case of Bitcoin and probably dip our toes into Ethereum a little bit. But the core idea behind this is that it is a database. So in a sense, there is a file, a database file. But what makes it very, very distinct from other sort of typical sort of databases that most people are familiar with, being, say, even a spreadsheet or going up into some SQL database, is that it's from the very beginning designed to be copied. Right? That's a key point. Right? It's designed to be distributed first and foremost. Now that's not actually unusual in any sort of database designs. Most of you will be using what are called distributed databases anyway, whether you know it or not. The second key point about the Bitcoin or blockchain architecture is it's not just to be copied or replicated within a single trust domain, a single trust boundary. It's actually designed to be copied across trust boundaries, across different agents that we do not necessarily trust. Or mutually trust is a key point here. So it's specifically designed to do that. And in doing so, it creates that replication or copying of that database. Basically creates a network, right? And those participants in the network, we do not necessarily trust because we don't have control over them. So a blockchain is a database in this sense, but often the way it's framed, and indeed in the decision there, it's framed as basically being these discrete crypto assets, when in fact that's not the case. The database that we're talking about here is fundamentally a ledger. Not unlike your Xero ledger, your NetSuites, your SAPs, or your any of the bank's ledgers that we operate an accounting system on. Right? That database is on every node within the network that is a full node, what terms as a full node. So it maintains this ledger on that machine. What then happens is this database, which is a ledger, which records all the current balances for accounts. Those accounts are identified by public keys, okay, which is in cryptography, we're using public key infrastructure, which is what all these do. There's a public key and a private key. The public key means something we can make available, and it's a public name within the system. The private key is a bit of information that we can prove that we have got control over the public key. Now, what control means will obviously be defined by the systems of rules of which the key is actually used. The public and private key are used. Because this is a database that spreads across trust domains, across lots of different people, it's a ledger, that's its semantics, it's just like an accounting ledger. The way in which we update that ledger is really, really important. And so the ledger in Bitcoin is called UTXO, which stands for the unspent transactions, unspent transaction outputs. And that basically keeps an account of what public keys have what balances in simple form. And then the rest of the system that you often hear about in terms of the transferring of assets, etc., is really actually one big giant computing state machine. And these are messages that say how to update that ledger, all the copies of the ledger. Right? So it's those messages, if you like, are distributed around all the nodes in the network to say how to update your local copy of that ledger. Right? So that all of us come to a consensus around what accounts have what balances. So that's the essence of what a blockchain is doing, and hence why you'll be often referred to it as a distributed ledger or of some other form like that.
There's a good question, Robert,
yeah.
from Judy, asking if you could explain the difference between that blockchain type of ledger and the blockchain type of database and the SQL database that is mentioned in the case.
Right. So the SQL database, well, the key assumption here is the design of this particular database is this idea. One, it's meant to be distributed. Two, it's meant to work across agency boundaries. That's the key difference. The other factors of it, for an SQL database, it has a query language, it's optimized for local performance, etc. But it does not really, it makes a big assumption about the integrity of the data that's stored in that database. The integrity here is that it's, for a SQL database, is the entity or the unit controlling the database has the ability to update that database unilaterally. They can make the decisions to change it. And therefore it relies heavily on their internal protection or security mechanisms to prevent anyone from accessing it externally or inappropriately. That includes insiders, so people working on the inside. Whereas a blockchain kind of database is fundamentally designed to be shared, designed to be replicated. So the choice then becomes, what the heck? How do we manage these updates when I don't even necessarily know who the person is that is making the updates? I don't know the company or the individual that might be doing them. So that's the key distinction. On top of that, it makes a lot of trade-offs. Engineering is about trade-offs. So an SQL database designed to run locally on a machine, such as in your browser or anything, will make different trade-offs to one that's designed to run in the cloud and to handle very large loads. Likewise, a blockchain-based database is designed to trade off performance over data integrity. in that particular context. And that's the fundamental difference between them. In addition to that, blockchains themselves are not necessarily as flexible as an SQL database. You can't arbitrarily go and design your own database and do things. There's rules around doing that. And different blockchains will vary along those different lines. So the key point here is this replicator database that maintains a current state of the ledger. And then everything else is about how transfers happened. This is very much similar, and since the decision refers to it, very similar to the idea of payment transfers in a banking system. Whether it's doing wholesale or retail, there's going to be a ledger entry that updates accounts in different types of accounts. And that's the essence of what's going on. What gives you the right to do the update is first and foremost that you've got possession of a private key. But then there's a whole set of systems of rules which are maintained by consensus by nodes within the network. Right? So that's the way, that's a different perspective than coming up from the bottom up. And the idea here is that literally anyone in the world without permission could go and grab all the transactions that have occurred and recreate that database and know with a reasonable high degree of confidence that it's a copy, a genuine copy, or reflects the current state of the overall network. Right? So that's the essence of it. And so after that, what the accounts mean, what rights you have, etc., are largely determined by the rules of the network itself. And in the case of Bitcoin, those rules are determined by script, by a little scripting language that you can, in principle, cover a lot of different rules. But in practical terms, it's locked down to a limited set of transaction types. Where Ethereum came in was to actually say, well, actually, we can generalize that more to do more interesting things. So this is a general platform in the case of Ethereum that is enabling us to transfer some unit of account. What that unit of account means and what rules are associated with that unit of account is up for individual project and protocol definition on that side.
Can I just, there's another question here, and it just seems the right time to ask this, although I think it's probably something that some of the legal people might have a view on as well. From Mark saying, it seems like we should be comparing particular assets and determining the difference between digital IP, digital goods, and digital financial assets based on the actual information content and the intent of the issuer. I'm not sure if I agree with that, but the fact that we should be looking at different types of digital property. Maybe Bitcoin is property, but Ethereum is not. And I'd be quite interested to hear some of the legal people respond to that.
Yeah, so with what I've just described there in that sort of particular question, any thoughts on what I've discussed or how to change things like things in action versus things in possession? The comments that Mark has made just there as well.
Could I come in
Yeah.
on this? I want to sort of roll it all back to some fairly fundamental principles. And the first and most important principle is that information in and of itself is not property. And there's a line of cases in England in particular that have held that. And there was a recent case in England where there was a database that was being held by basically a digital warehouse where the fees hadn't been paid. And because the fees hadn't been paid, they said, all right, we're going to exercise a lien over this. Now, you can exercise a lien over a car that's been repaired, which you haven't paid for. But in this particular case, the owners of the data, if you like, said, well, you can't do that because it isn't property. And the court said, that's right. Now, that particular line of authority in England has created some difficulties, because the conclusion that you draw from that is, okay, digital files are not property because they're information. Then you get the New Zealand line, which is incorporated, has its starting point in Dixon, a Supreme Court decision, where without any detailed analysis at all, the Supreme Court came to the conclusion that a video file, in that case, was property, and that was the way of it, and that has been the law as far as New Zealand is concerned. Now, my concern about that is that that does not, in fact, reflect the technological reality of a digital file, because if you look at it in its most basic sense, it's a whole lot of ones and zeros scattered across the medium. Very, very difficult to actually identify. So how do you fulfill those various important aspects of property? Like, is it identifiable? Can anybody else identify it? Can anybody else assume control of it? And does it have any permanence or stability? And of course, we all know that information in the digital space is very, very dynamic to start with. So nobody had actually said, okay, let's have a look at this and analyze it properly and see whether or not this can fall within the concepts of property. And that was where Henderson and Walker came in, because the court there actually did carry out that analysis, and it did do that necessary thinking. And the court in that particular case, Justice Thomas, came to the conclusion that we are talking about what she referred to as digital assets. Now, I thought, well, that's pretty interesting. When you look at digital assets, of course, that can also apply to cryptocurrencies. But the digital assets in Henderson and Walker were different from the digital assets in Cryptopia, because an email file, which was one of the files in Henderson and Walker, is a little bit different from a blockchain file or something of that nature. But I thought that the clue actually sat within digital assets, and in that respect, you've got to separate what I call the technology from the content. And this is an argument that I've had in many, many other areas in this whole digital thing, where we focus far too much upon the content, and we don't actually look too much at the technology. So the way that I see it is that if we say we've got a logical way of describing the information on a file system, then we can separate that from the content, and we don't get ourselves into all sorts of problems about intellectual property if we maintain that dividing line, if you like, between the content on the one hand, which is property but of a specific and special nature, which is intellectual property, from something that is identifiable by subject matter, identifiable by third parties, can be assumed, and has a degree of permanence and stability. And I think if you look at that, what I call the container theory, what is the information contained in within a logical context, then you are heading towards a way of analyzing whether or not blockchain, emails, video files, whatever, all the various different flavors of digital content and the ways in which they're stored can be identified as property. And that was the point that I was trying to make, and that's why I think this case has so much wider significance, because if you look at Henderson and Walker and follow through with the Cryptopia case, you're beginning to develop that analytical pathway. I understand and I agree, Robert, that there are some difficulties about the precise definition of cryptocurrencies, and it probably was the wrong case for lawyers to get involved in, because it's terribly complicated, and lawyers, with the exception of the few that we have here, aren't known for their technological abilities. So yeah, it was probably difficult. I thought the judge actually did quite a good job. Got most of it right, but yeah, that's my thinking on it anyway. And what I was wanting was something that is legally sound, but also reflects technological realities. And in that respect, I'm probably a little bit, well, probably describing myself as a purist is wrong, but a little bit more of a purist than Rick, who looks at it from a value point of view. Perfectly correct. I have no difficulty with that whatsoever. But I guess, you know, I like the idea of getting it technologically correct as well as legally correct. So that's where I come from on it.
Well, having invited me, Jamie, to come in on that, perhaps I can respond, which is that I'm actually starting to struggle with this somewhat out-of-dated historical concept of information not being property, because and we can see the mental gymnastics that we're having to do to design things called container theory and so on, which are really a recourse to a particular type of technology.
Okay, if someone could flag in chat that he's dropped out just at the minute. So, yeah. I mean, this is a bit unfair because my instincts line up more with David's. I want the idea of property to be conceptually coherent in terms of, because it's really meaningful and useful in technical legal contexts, but it also ties in with a lot of intuitions people have. So I've been trying to think this through, and I think we're hopefully getting to a Goldilocks view, because there's what people call the bundle theory of property, which is that it's a collection of rights, and that which rights go with it could more or less be chopped and changed as you like. It's quite a thin view. There's a really thick view that property is some kind of inherent concept. There's some natural law thinking that includes very strong instincts about property and it having to have certain properties. And I want the middle view, the Goldilocks view, which is just right, which is that property and law works like a technical protocol. So there might be some flexibility about how precisely it's implemented, but there's some features you want it to have. So I'm going way back to, like, what is the value and the point of calling something property? And it lets people identify who that this thing of value, someone has the formal legal right to say what's done with it. So they might have title. Someone else might be using it at the moment. So you have title, and they have possession. And a nice simple case of that is renting out a property so that one person formally owns it, another person is able to live in it. And the value of property is that it makes these transactions kind of easy, and you can do all sorts of everyday things like take clothing to a laundromat to get cleaned, or take your car to a mechanic, and you want the law to track intuitions about who has what sets of interests in those things, just that with all these transactions taking place, and also without having to explicitly contract and document them all. And I'll pull on a few threads for why I think there's some limitations on the protocol. So in the background of all of this is policy decisions around what should be easy for people to do and understand. So you have things like the doctrine of first sale. You can buy a book that is copyrighted, and the person who has produced it might purport to give it to you under a license agreement that stops you using it in certain ways. You're not allowed to quote this bit of the book in a publication from one of our competitors. And the doctrine of first sale says, no, at some point, the property interest of the person who made this has to run out. It would be ridiculous if we had to track the full chain of transactions all the way back. It's not practical. Life can't go on like that. And these things become particularly relevant when you're dealing with digital stuff, which can be very cheaply copied and shared. And so that's where I was going with the comment on the nature of cryptocurrencies earlier, because they, rather than taking a legal route, take a technical route in the way that Robert set out to take things that are otherwise easily copied and shared and put some constraints on how many times you can copy it and who has the title and control over this thing. So that's a few different directions for why I think there's a need for the idea of property to be coherent so that it lines up with the intuitions people have. And I think that the decision in Cryptopia is probably getting the right outcome. But the need for coherence is why David and I have been hoping for better and more complete reasoning. And that's started to develop with Henderson and Cryptopia. Now, one thing that remains a wrinkle that I would like to see grappled with is the idea of things that are non-rival in economist terms. So there's some types of goods, like my French press. If I've got it, someone else can't have it and use it. And then there's other types of things in the world, and this is where information is a particularly interesting sort of category. My having information and using it doesn't inherently deprive anyone else from doing the same. And the analysis, even though it's getting towards the way we'd want it to go in Cryptopia, is kind of ticking off existing property tests without necessarily explicitly engaging with the idea that information can be copied and shared and is non-rival. And there's some economic and policy and social upside to that. That's not explicitly there in the tests that are considered for what makes property. And I think it would be useful for some analysis to go in that direction. And that might be a way of carving up what is the difference between these crypto assets and other kinds of digital assets that may or may not get different treatment.
That was certainly the approach in terms of non-rivalrous goods and so public goods and club goods, which was the approach from the data commons point of view, because basically the idea that data or information actually gets its value in use, not specifically being stored away. And so how could we manage what was going on there? Ruscoe, do you have any sort of comments? Rick seems to have completely disappeared off the face of the panel, so I'm not sure what's going on there. But Ruscoe, do you have any comments?
I'm about to, my internet's going in and out quite badly as well, so I'm hearing about half of this, unfortunately. And I don't think I do have much of a comment, except that the different analysis of property between cryptocurrency type assets versus other types of information, I think is a really interesting place for me to look further into. And I'm also interested in the impact cryptocurrency type assets as property have on what happens next. So, and I'm thinking particularly, I know that in technological circles, there's questions around whether, for instance, is the code the law? Does that define what happens, or can the law impose itself on the code? So I'm kind of interested in, I haven't, to be fair, thought through how that, the description of cryptocurrency as property impacts that, other than looking at issues of what happens next when this currency has been stolen, where the extent to which that has been touched by the trusts or that have been imposed on it here. So are we saying that the code is not law? Comments, please.
Whoa!
Yeah, I was going to save that particular one for later on when we talk about as a smart contract to contract.
Oh, sorry.
But definitely come back to it.
There's a comment in chat
yeah,
that it might be helpful to address.
that's what I was thinking. Yeah.
Which one is that?
Sorry.
So Kay has said that it's interesting to compare the concept of property or digital asset with the definition of publication in the Films, Videos and Publications Classification Act 1993. And that includes a very broad set of things. I've also, and I'm possibly needling David a little bit, referring to the definition of document, which was important to what reasoning was offered in Dixon. And I think all these things are useful, but as David has pointed out to me, it's important to look at what specific term is being defined and for what purpose, because all these definitions then feed into operative statutory provisions. So I've been looking at the classification regime because the government is looking at reviewing that partly in response to extremist content online in the wake of the Christchurch terror attacks, and are looking for legislative remedies. And the definition of a publication is for defining the scope of that framework, at least as it occurs there. The definition of document, and this might be a gateway into some of my disagreements with the reasoning in Dixon. The decision there sets out that a Microsoft Word document as a file that has content that digitally appears on your screen as if it were on a piece of paper. And because it's within the definition of document, they don't explicitly say this, but they then make a move towards saying it's property. And what I was getting at in my remarks before is that saying something's property is about who has control, who gets to make choices about it, and when do you say it's the person who's physically holding it versus some other person. And that's a different set of purposes from saying something's a document. The reason you say something's a document is to look at whether its information content is available for reasoning as evidence or for some other purpose. So we have to be careful. We might think that a document as such is property in the physical world, but we're talking about the piece of paper or the book it's written on. And one of the things that when things are digital, we might have to carve these up because they don't necessarily go together in the same way.
Yeah, that Films, Videos, Publications Classification Act, the purpose of the legislation, of course, is to deal specifically with one thing, and that's content and nothing else. What they have is a very, very wide definition of the form of that content, the form that content may appear in. It may be in a film, or it may be in a digital file, or it may be in a book, or whatever. But the wider the definition, of course, the more things they have a right to classify and make a decision upon. The issue of document is an interesting one, because when those definitions in the Crimes Act were set out in the various amendments that have taken place, they were primarily looking at the use of documents for the purposes of fraud or dishonest purposes. And what happened was that in Dixon, the Supreme Court made a bit of a leap, saying, well, a document can be a file, so why can't a video be a file? And if a document is property and is a file, and a video is a file, then a video can be property. And they hadn't sort of gone into the proper sort of analysis of the nature of digital content and the fact that it can have all sorts of different classifications, if I can use that word. So yeah, you've got to be very, very careful when you're looking at legal things to make sure that you understand the purpose of the definition, because to try and cross-fertilize, if I can put it that way, one definition in a statute with another purpose in another statute, or another purpose for another role, you get yourself into difficulties. And as you've probably gathered from my earlier comments, I'm kind of rigorous as far as legal principles are concerned, and I like to see that rigor being applied. So that's my thinking on it anyway.
Cool. What I was interested in now here, in terms of what you brought up, in terms of the context, this decision has been made in the context of the Companies Act, and specifically for the purpose of insolvency. The analysis that's occurred in the decision here, how easy is it, or how will it be sort of, like you said, taken further and cross-fertilized in a sense?
Well, I think it's broad enough. In Cryptopia, although it was within the context of a liquidation, I think that when they're looking at whether or not it's property for the purposes of the company liquidation, the way in which the court has approached it is that it's broad enough to say, well, we can apply the reasoning in Cryptopia to another situation. So if we are going to be looking, well, if, for example, speaking completely hypothetically, there were a criminal prosecution that involved dishonest use of property or something like that, the reasoning that Justice Gendel had in the Cryptopia decision could well be applied to the criminal prosecution as well. Now that is a theory only. I don't want to be taken as predetermining the issue at all without hearing argument on it or anything like that. But it is possible that the Cryptopia decision could cross-fertilize into a criminal prosecution, because it's wide enough in its reasoning to be applied for that purpose. Does that help?
Yeah, yeah. One of the other questions here was just that you mentioned earlier in the piece about trying to make the decisions both legally accurate and technically accurate. And I highlighted that there were actually some inaccuracies in the way that the system was described. The biggest one, most glaring one, was the idea that public key actually embodies all the data of the transaction in the accounts, which that is not the case at all. How would one go about trying to improve those sort of decisions that bring those two closer together, the technical alignment and the legal alignment? Good question.
Yeah, well, get judges who are techies,
right.
Would be a good start. I think the way in which you find out about technological information is by way of expert evidence. So you make sure that when you are hearing expert evidence on something like cryptocurrencies or something like that, it's coming from an approved source, or it's coming from a recognized source. And there are all sorts of different ways in which that expert evidence can be adduced. And courts can also take judicial notice of accepted facts within a particular discipline. So it's very much up to the lawyers. And I think we're beginning to develop a coterie of lawyers who are tech savvy, who know what it's all about, and who know how to adduce that particular evidence. I can think of one case which involved Google Ads, and the lawyers involved in that particular case were right up with it, and they did a terrific job in explaining to the court how it was that Google Ads actually worked. And the judge who delivered the decision had no idea at all about how Google Ads worked at the start of the case, and he completely and utterly nailed it in his decision on how Google Ads worked. It was brilliant, and it was all because he was properly informed by expert evidence, and that's the way that you get it. You actually don't need to have a degree in computer science as a judge to do this, although it helps. But yeah, expert evidence is the way.
Okay. Yeah, I can concur with you in terms of the decision itself, the decision quality or the analysis of it is actually not bad at all as far as I can determine. As I say, the technical inaccuracies don't actually detract from the analysis itself in that regard. I was just wondering, Judy's got a whole lot of questions in the Q&A, even though David's answered them and stuff like that. Judy, would you be interested in talking about them live?
I used to be a property lawyer, and I was actually taught company law by Peter Watts QC, who acted in that judgment. So this is quite a interesting case for me. And yeah, I just did some studying as well. So I think, in my opinion, I don't know if you can see me. In my opinion, I think the thing that the judges didn't even need to go there to say whether cryptocurrency is property or not property, because the thing that they actually stole was the private keys, and that the private keys were kept in an SQL database, super insecure, and they were just taken away. So in terms of the facts fitting the law, I don't think the facts of this case actually fit the law properly. And this is an unusual hack. For me, the big thing here seems to me, in the combination of, in my experience, is the private keys. So the private keys. So how cryptocurrencies work, I think, well, correct me if I'm wrong, Robert, is that you trade you have these cryptocurrencies. You can either mine them or you can buy them. You can buy them using normal money, New Zealand dollars or whatever, or you can mine them. You can make cryptocurrency by using your computer and things like that, or you can trade it with the cryptocurrency that you have. So there's different types of cryptocurrency. There's Ethereum, there's Denta coin, and there's Bitcoin. And that was the frustrating thing about the judgment for me, was that the judges seemed to be confused with the difference between cryptocurrency and Bitcoin. Bitcoin is a type of cryptocurrency. It's not actually, it doesn't represent all cryptocurrency. So that really made me annoyed. And also the other thing is the thief actually stole private keys from an exchange. And to be hard line about this, people who trade in cryptocurrencies expect this. There's a saying in crypto that, you know, not your key, not your coins, you know. So if you lose your private key, then sorry, you know, tough luck. You can't actually go to court now and go, oh, I want my money back, or I want you know, I want my sorry, Mark just said something. I want my keys back, because the account holders actually in this case wanted their cryptocurrency back. They didn't want the money or the value of the money. They wanted the keys. The problem with this Cryptopia hack is that it's an unusual hack, even in cybersecurity perspective, because most cryptocurrency hacks are just a single wallet, and people, you know, hack. And they do it really quickly. They transfer the cryptocurrencies really quickly into their own wallet, and then into another wallet and into another wallet. But with this hack, it's still sitting in that wallet they've transferred into. And you know, because of how public this hack has been, it's it's been flagged on Etherscan that this wallet is the wallet of the Cryptopia hack. So I know this, I may sound like a conspiracy theorist right here, but it may be an inside job, or maybe someone who has really I don't know, a really comprehensive understanding of how Cryptopia's software architecture works in order to conduct this hack. You know, and also like this is one of the things also that irked me about the judgment, is that Cryptopia, the difference is that the Cryptopia itself actually uses an SQL database. They don't actually use a blockchain. If they had used a blockchain, this wouldn't have happened, right? Like, you know, there wouldn't be.
Yeah, that's correct. One of the key things with the decision was there was actually a conflation of an SQL database, and you know, the ability to keep the accounts and the integrity of them versus a blockchain. They're quite different from that point of view. And yes, it's highly possible that they could be an insider job. I have no idea on that side of things. And it's not uncommon for any of the, when funds or, you know, tokens basically, or cryptocurrencies have been taken, that they end up in a wallet where they just sit. Or what we mean by wallet here is actually we mean by public key, an account. A wallet really is just a collection of a whole lot of public keys, private keys, and matching public keys.
Robert, the important thing with Cryptopia is that it wasn't about the stuff that had been stolen. It was about the remaining cryptocurrency assets, if you like, and whether or not they amounted to property for the purposes of the liquidation. I was very interested to hear what Judy had to say about the nature of the hack. And the question that I have is not whether or not a cryptocurrency may be property and whether the reasoning can be imported into a criminal case, but whether or not, and this is an entirely different question, the key can be considered property. And that opens a whole different can of worms. Wow.
I did wonder that. Yeah, I mean, I did wonder that. I was like, well, you know, if I were the judge, I would probably just, you know, be a bit more rigorous, as you say, and just say, just the key is property. I'm not even going to talk about whether cryptocurrencies in general property, just the key.
But for the purposes of the liquidation, it was important to determine whether or not the cryptocurrency was the property in that particular case. But hey, interesting point.
Yeah,
wow.
well, probably a title to a property, right? Like I wondered whether, you know, maybe a title framework would work rather than a property. You know,
just to use the analogy, if you steal the key, do you steal the car?
Yeah, Mark Wilcox has said that in the chat. But I think we're talking about a different cause of action, because it would be the analysis might be right, and it's interesting. It would be the people who'd had their cryptocurrency lost, pursuing the managers of Cryptopia for some kind of constructive trust. Or you know, whatever the basis is, saying you held this property and the keys for us, and you negligently or recklessly or criminally, in the case where it's an inside job, caused it to be lost and caused us to lose its value.
Yeah.
I'm just taking that car analogy a little bit further. Imagine we have a self-driving car with some kind of you know, where the key actually does give you possession of the car. So stealing the key in that case is actually stealing the car, isn't it? Because you can move the car to wherever you want to once you have that key.
I guess, yeah, I think to Mark's point, yes, but in cryptocurrency world, because it's so decentralized, and actually there is a benefit of having centralized record keeping, centralized ledger, right? Because with car ownership, we have a record of car ownership separately held by the state, and so we can say you know, it's not finders keepers. You know, just because you've got my key doesn't mean you've got my car, because I'm the registered owner in the separate ledger, the separate centralized ledger owned by the government that says I own this car, and so you got to give it back. But you know, if it was a watch, yeah, finders keepers.
With that, I was just wondering if Laurie, you've brought up an interesting point here in determining whether cryptocurrency is property or not, something that's pretty close to my heart, so to speak. I was wondering if you would like to talk about it a little bit.
Hello. Yeah, I'm also an accountant by profession, so I think that's where I'm coming from. From an accounting perspective, so what's also considered is how the cryptocurrency will be used. So actually recently in the Philippines, where I'm from, the Philippine Institute of Certified Public Accountants came up with material that guides that provides guidance on how to treat cryptocurrencies, whether to treat them as assets or currency, and in most cases, given that they are either bartered or mined, or they are treated as assets rather than currency, because they're not regulated by the central bank as well. So it will be quite difficult to also give them the treatment of currency. So I think the mainstream view in most cases from an accounting perspective is that cryptocurrencies are assets, and hence I think from there the legal treatment should also flow, just for consistency.
Thank you there, Laurie. So that's actually quite an important sort of perspective. I think that adds to the mix, because what we've got here is not just technical and legal technology, but it's actually also accounting. So there's that, and it's also an economic system, microeconomic system. So there's sort of these sort of things, different perspectives come in to define what a blockchain-based digital asset is. So I was just wondering, Alex, did you want to say anything at all?
I just quickly on the point about the stealing private keys. I think we've got to be careful, because what would have happened with the customer, my understanding is the customer sends the cryptocurrency to Cryptopia, who then receives it, puts in its own wallet. So it's a completely different private key now. And also it becomes dangerously close to the problem of information property. So again, that's another technical issue. It's not those, it's when you have Bitcoin, it's not like the same private key is always with that Bitcoin. It just depends who's got it. So that's why it's a sort of separate asset, if that makes sense.
Absolutely, it does. This was another key aspect within the decision, was that it was kind of saying a single unit of whatever the cryptocurrency was actually identifiable. That's not the case.
Exactly.
It's basically an account which is identifiable, an account as in like a public key, and the public key holds a balance. The actual units, which are Satoshi, which is the smallest single unit, identity unit of Bitcoin, or Way in the case of Ethereum, are fungible, completely and utterly fungible. Just as like if I put money into my bank account in terms of cash, that money will pop out somewhere else to someone else, but the balance remains in my account. So that was a key point, and there was confusion, I think, in the decision around that. Is actually what you're doing is transfers on that side of things. Now, with that, and while I've got you on, Alex and Rochelle, I just thought we'd try to move the discussion a little bit down to digital assets and trust, the key reason for the decision, and just whether or not what sort of comments and stuff like that you might have on the decision's reflection on trust.
I can go quickly first if you want.
Yep, thank you.
I think it's this case turns on its facts. So the user, the terms of service, whatever, were very clear that Cryptopia are holding it on trust. And so from that point of view, it was very clear cut. But what was interesting with it as well was the fact that some people had their funds removed, so stolen, but there was still most of it there. And I think what the judge did was to sort of apportion it so everyone got the same amount, and you're not trying to work out, who, loosely saying whose was stolen was sensible. But that's how I read it. I don't know what you think, Michelle.
So yeah, I mean that trying to determine when you've got any insolvency or theft where there are less assets than people have rights to assets, if you like, or at least less assets than people are expecting to receive, you need to work out a fair way to do that. And that's what most of the cases around investments and so on in the 80s Equity Corp and so on had that kind of issue where you have Gold Corp. There were a number of different cases that looked at where money goes in and what way, or money or assets, what way is it held, and how do you determine what's fair. And I was interested that they the reasoning around deciding that each type of coin was a separate trust, so that if there was a percentage stolen from each type of coin, so each type of currency, then the people lost, if you like, in the same percentage within that trust. So I was interested that was around how they Cryptopia had actually stored that currency, and I'm not sure. And I think it's very fact specific, because I don't think you could say that in another case that's exactly how it would pan out. You would need to look at your terms and conditions, the way that in fact things were stored. So in a way, the way the technology has been done is actually going to impact whether what the impact would be if there were a loss or a theft in a future set of currency. So it's always really interesting, because when a company is solvent or when there hasn't been a theft, you can just look and say, well, I put my money in, I get my money out. That's how it works. And there are so many ways of applying fairness. What is fair when actually everyone's going to lose out? And that's what I find interesting about applying the trust law to this. The other thing is, I think some people might be wondering if there is this trust over the currency, what happens if that currency is stolen and then quickly transferred on? Does that mean I can't trust that currency anymore because it's been, it's gone on to someone else? What if I receive some of that currency and I don't know if this is the currency that was under the trust? And I think it's important to understand that trust concepts like knowing receipt and knowing assistance will impact that, so that if you are a genuine person who purchased the currency for good value and dealt with it without any understanding that it was in fact this currency that had been stolen, you're still, normal trust concepts mean that you will actually receive that property in full. It won't be touched by the trust, but if you have aware of the infidelities, aware of the issues, or not received the property for good value, then actually the trust concepts would mean that you might actually have what you think is your property touched by the court. Does that make sense?
Can I just butt in?
Sure.
So, I was thinking about what David said about information being property, and I think there is a trust here, but the trust is actually not holding a property on trust. It's actually holding information on trust. So they have actually a fiduciary relationship to the account holders to keep that information confidential. And the reason why this whole hack happened was because that security breach, that because of the hack and because of the breach of the confidential information, which is i.e. the private key. And I think we, I guess I agree with what's her name, the other QC, not Peter Watts. In that case,
Generally,
this should be this should be a matter for Parliament. This should be a matter for not for.
You think they'd be able to get it right? Come on.
Well, at least there's consultation, right? You know, that's part of being a democratic.
Look at what they're doing right now. They just shut the country down.
we will all be making a submission. This was
no,
will they listen?
I think
probably not.
but there is very good reasoning that cryptocurrencies are property. I've forgotten the name of it, but that opinion written in England by I mean, that's, you can't fault that. I mean, I just think it's that wasn't the most interesting bit of the decision, but there were other things that were sort of more interesting than it.
I agree, Alex. Actually, Rick mentioned a really good point earlier on, saying that what you put monetary value on should be considered property, and I agree with that in principle.
Yeah, because also things like some people have quite substantial holdings of cryptocurrency, and if it's not property, then what happens when people die? You know, and people are buying and purchasing. You know, so there's a whole lot of knock-on consequences.
I agree that it's the fact that it's property or not is that seemed to be a dead cert. I can't see that part of it being overturned, and yeah. It's the trust stuff that interested me a little bit more, just because of the impact of how that operates and what that means, and
No, me too.
and the way a lot of technology people understand where the cryptocurrency sits within our community. Can you hear me, or am I breaking up? Okay. So that they're not necessarily, they're seeing it as decentralized from law, almost from jurisdiction, and actually law is reaching out and touching it in the way that it will other things, and I think that's probably right. That's the right thing to do, but it's just an interesting perspective for the people who see it as something that almost sits outside the law.
Yeah, I want to comment on a couple of things that Rochelle highlighted. So the allocation of separate trusts for each cryptocurrency asset, that intuitively appeals to me, because people are making a series of risk decisions when they're making an investment, and these are all assets that can be very volatile, and it would make sense that the person who's chosen to hold a certain amount of a cryptocurrency bears the benefit or risk from that. They've also made a risk decision to go with this exchange, and so they're also making a bet on the robustness of the terms and conditions and the actual operation of that exchange. And I think to what Rochelle was just commenting on, it's the broad question of how do we do dispute resolution, and which bits of it take place on chain, and which bits of it take place off chain, and the interface between those, because it's probably not the case that most cryptocurrency platforms have robust estate law consideration in their on-chain dispute resolution. And if someone passes away, if that's a gap in the technology platform, then that is the kind of situation where the law steps in. Where that gets really interesting and complicated is, so I think it's okay in Cryptopia because the liquidators can go through the system and get the keys they need to allocate what's reflected in the servers they have access to. What would get really interesting would be where you develop this body of law and you have definite answers that someone has title to a crypto asset, but the technical capability to actually allocate it to that person isn't there. And so there's a mismatch between what our legal system would say and what's possible in the on-chain resolution of those claims.
Right. Tim's made a question, and Rochelle sort of indicated you will answer that. Yeah.
I did. I've just actually been cut out and I've missed that entire chat. Sorry, James. I'm back on now, and I accidentally clicked the button for answering this live, but I do have a comment live. So Tim has said, I don't think it's quite right that anything that we put financial value on is property. That's question begging. Things get financial value because they are property. And I understand that. I think the value, though, that is one of the things that needs to be taken into account when determining whether or not it is property, but understanding, of course, that by calling it property, it is going to improve
No, we're Rick has indicated that his router was fried.
I don't think
on the
we
fridge,
can
so he
separate
hasn't come in.
that.
And Rochelle is dropping in and out as well.
Can I answer that? Help
Yeah.
Rochelle and answer that, because I know Tim.
Yeah.
Hi, Tim. I think, but we're in new territory here, though, because we're trying to define what property is. Like, we're pushing the envelope of what property is, and one of the determinations, well, one of, like, they cited Lord Wilberforce's, if you read the judgment, they cited Lord Wilberforce's
Ainsworth. The case is Ainsworth.
That's right. Thanks, David. And one of the things it talked about is having some sort of stability. And I think having a financial value, I read that stability. I read financial value into that stability side of things, because we put value on it. I mean, similarly, you can say that intellectual property is not property, because, you know, like, it's just bits and bytes nowadays, or radio waves that's being transferred. So, yeah. Oh, Rochelle, you're back.
You can have property that has no value. It can still be identifiable. It can still be assumed by third parties. It can still have a degree of permanence and stability, but it may have no marketability whatsoever.
Or negative value.
Have a negative value.
And it
So
can
like
still,
oil coming into Oklahoma.
It can still be property. It can still be property. Even
That's
though it does, so value is just one of a number of criteria that has to be taken into account.
Yeah, and that's essentially what cryptocurrency is, right? It's so volatile. It's so we do not know what the value of a certain cryptocurrency is, because it just varies so much. I mean, look at Bitcoin. Like, how much is Bitcoin worth now? And you know, and that's I guess another issue I have with defining cryptocurrency as property, because if we define cryptocurrency as property, can we pass it on to our next generation in a will? You know, like, can we say, I give my Ethereum to, you know, my son? By that time, when my son is, you know, of legal age, maybe Ethereum's worth nothing.
Can I bring in another perspective of that? And I'm conscious of the time here, because I do want to get on to smart contracts and stuff. But Mark Wilcox has been sitting out there with a lot of feedback and stuff like that. So I was wondering, Mark, do you want to dive in here, with particularly around that last point where you've made that Judy was saying the volatility of cryptocurrencies are going up and down? Would you like to bring in sort of this idea that they're the most accurately priced aspect? Do you want to dive in, Mark? You okay with that? Yeah, go. Right, I'll make you a panelist, Mark. And
yeah, so I think, like, if you look, it's probably more accurate to say that they're very volatile in their value, but the actual price of them is pretty accurate, because there's lots of different exchanges and lots of countries, and it's not like they're not constrained in like a NASDAQ, where there's all these different things that people can use to influence and control access to the assets. So they're pretty open, anyone can mine them. And it's just that they basically have no underlying value. So it's just pure market perception about what is going to happen. But if you look at them over time, it's pretty stable, like Bitcoin, because of the infrastructure is pretty massive. And you know, you can look at the trends and so on. So there's a pretty good measurable relationship between like how much energy is put into mining the new coins and the value of them across lots of exchanges. But you also have things like stable coins, which are kind of rights issued for, like, a bank will be holding onto a bunch of dollars in a bank account, and they will, you know, commit to the, you know, trading it. So, you know, like if Cryptopia was hacked when stable coins were around, then there would be a bunch of like digital US dollars effectively sitting in an account as well. They would have all of the same problems around interpretability. So the value, the price kind of aspect is probably mostly comes into what were they trading, you know, on the exchange. Because I think the right over, you know, getting some money back out is different from the ownership over a particular coin on the blockchain. If that makes sense. What do you think, Robert?
Yeah, no, I agree. I could wax lyrical about the pricing stuff for quite a while in terms of what's actually going on there. You also raised an important point around the reference to the database, so it's gone somewhere, that in fact, certainly within the decision, there was some sort of oddity that I thought there was a kind of like the SQL database was seen as authoritative. Yet there were statements like they didn't have reconciliation of who put what and where. And so I haven't been following too close to the technical aspects of it, but that was particularly interesting, that essentially whether keys are stored on a SQL database, which was like if that's true, that would be kind of like a naughty 101 not thing to do. That would be only marginally better than putting in a text file on the file system. So there was certainly no clarity around that, but then we didn't expect that in that decision anyway, because this was, as David pointed out earlier, it was specifically about insolvency provisions within the Companies Act. What I just want to do now, because we've only got really 10 minutes, and I wanted to get, and while you're on here, Mike, wanted to go into what is a smart contract and versus a contract, because that was actually referred to in the decision as basically comparing the script code, whether we'll assume that it's either the Bitcoin script or Ethereum machine code, as equivalent to a contract written in words. And obviously David has hit back and said, no, it's not. So I was wondering, David, if you'd like to, first of all, just make a comment on that particular one, because this kind of starts to point into the future implications of what this thing is. We've only got a few more minutes left, so.
Yeah, I'm just sort of looking back on some notes that I've taken here about the issue of smart contracts and things like that. Once again, I guess, once again, the issue is whether or not you can separate the content from the container. What does a contract do? Alex will probably be able to do this better than I can, but it defines a relationship between individuals or between entities, if you like. So that is the content of the contract. It is contained within a particular framework. It could be in writing, or it could be on a handshake, a verbal contract, or you could have your smart contracts, which are sort of developing type of entities. But the important thing about a contract is what it says, how it was formed, and whether or not it contains the usual sort of criteria of offer acceptance, consideration, and so on and so forth. I don't know if that takes it any further. I'd be happy to expand on any questions that there may be on that. But once again, it's that content versus container type of approach.
Right. One of the interesting aspects of pretty much all the cryptocurrencies and blockchains that are associated with this, there is some variability around this, but largely, if we take Bitcoin as the case, the actual transfer of one Bitcoin or a fraction thereof is basically defined through a script, a little program, tiny little program that is guaranteed to actually run with what we refer to in computing as determinism. So you can actually determine that each instruction will do what it's supposed to do. Now, there's a lot of stuff under the hoods. That doesn't mean that's always true, but in principle, the idea behind Bitcoin and Ethereum is that all these different machines running around the world will validate that transaction. So we've got a consensus over which that was actually a valid transaction, a valid script, and it produced from the same inputs, it produced the same output. Those scripts are well understood. Those scripts are, in many cases, as we go further into like the Ethereum area, where we start to get the notion of protocols, upper layer protocols that define all sorts of digital assets, and not just digital assets and ones that may carry value, but ones that may confer voting rights, the ability to go through what James was talking about earlier, dispute resolution, etc. Those scripts, those protocols, etc., are normally specified in some way, and usually in words. Better that they also are defined in terms of mathematics, in terms of their operation, and the best, which we're only just starting to see now, is they're actually formally verified in some way. So there's a high degree of consistency. In principle, we could achieve a high degree of consistency in both what the contract says and how it performs and what our expectations are. So in that sense, I was intrigued by this idea that a contract is words. And so are, for example, diagrams still words? Are mathematical formulas still words? And also, if I can read the code and understand it, because these scripts are typically very small, and I've got the capability to do that, where is the boundary? That would be sort of like sort of a parting question for you, David.
Okay, the scripts seem to me, from what you've described, as an aspect of performance.
Yes.
Of the contract. So it is the script that is responsible for the particular performance. So what the parties would have to do is to agree upon what the script would do or say. In the same way that they could say, well, we will have payment by check, or payment by automatic transfer, or payment by internet banking, or something of that nature. Only in this particular case, they're defining a script, and so that would be part of the arrangement, if you like, between the parties. You can, of course, you can have a diagram as a part of a contract. You just need to think of a building contract, for example, which will have a whole lot of plans annexed. You can have a mathematical formula for a contract. You can have a chemical formula for a contract. If I, as a drug company, want an organization to manufacture large quantities of the vaccine for COVID-19, then I would probably specify that as a formula as to what they've got to do, and what the metes and bounds of the particular product that they're going to produce would be. So it all boils down to words, or if you like, an expression, might be another way of putting it. Yeah.
Okay, James, you've got.
Yeah, I'd like to, I think I'm agreeing, but the word I would like to use is an invitation. So conventionally, when you go through the process of writing a contract with another party, and you might sign it at the bottom and keep a copy of it, you're inviting the other party to comply with the obligations they've set out there, and you're also inviting legal intervention, so that if it goes wrong, you're inviting the court to come in and hold the parties to the obligations they've set on the contract. But you can make different invitations. So you can choose an alternative dispute resolution, for example, and to that extent try and exclude a conventional court process from intervening, at least until that's walked through. And the question is, because courts tend not to like when they see what looks like a manifest injustice being excluded from things, from the ability to intervene and put it right. So the smart contract, the use of scripts, may be an invitation to trust the system. I think the interesting question is when courts are going to be content when someone's lost out and they try and make the attempt to bring it before a court, to leave it with the invitation to alternative dispute resolution or to resolution by the code, rather than taking it back to the court.
Cool. With that, we're running out of time. We've got a minute left. So my suspicion here is that to follow on from the discussions around digital assets and digital as property, that there's probably enough material to dive into what is the smart contract versus words. And certainly that would be something I would be particularly interested in exploring a lot more. And we can look at some of the other projects and things that are happening in this space, from Project Accord, Open Law, and all the sort of other protocol design aspects, and see how they, from a technical standpoint, how they map also onto law would be really interesting. With that in mind, we've lost Rochelle because of her connectivity, and we've lost Rick because his router got fried. I would just like, looking at the implications of the future for this decision really, really quickly, can each of you that are now on the panel, that includes Mark and Alex, I think, give a little quick summary, very, very short, because we've literally up with time, and just see what you go. David, if you'd like to start.
Yeah, I think Cryptopia is going to be a case that's going to be referred to in a number of courts around the world, and once again, New Zealand's a leader.
Cool. James, I was wondering if you could carry on with that.
I think that's right, and it's interesting as we figure out the Goldilocks approach to property and digital things.
Just
Judy,
right.
Judy,
what do you think?
I think Cryptopia, even though I disagree with the decision, will hopefully spark some sort of political change, because we desperately need regulation around this kind of Wild West financial trading. So yeah, I'm hoping that it'll spark off some political changes, not just judicial changes.
Alex, have you got any thoughts?
I agree with David.
Yep. Excellent, nice and short. And Mark, I was just wondering, since you're still in the panel there, got any thoughts of what you see this as being important or not, or what do you think?
Yeah, I mean, it seems like there's too much focus on private keys. It seems like the relationship between an exchange that's running just a regular database that owes some money to people is different from like a specific asset that's tracked on a blockchain. So maybe it's not really, like maybe that situation is not really a conversation around property assets, a question around what's the contract.
Cool.
I'm not a lawyer, so I don't know.
Yeah.
But I think it's going to get it's going to head more in the direction of more of these traditional files and things becoming like cryptocurrency, and not like any clarity around what cryptocurrency is, because it's pretty general.
Yeah. Okay, well, I agree with David. I think this is a really, really important one. So I look at it from a technical lens, obviously, so it's nice to hear the same sort of, coming from a legal point of view, that everyone agrees. And I also agree with Mark in the sense that it's very important from that a lot of stuff is going to move forward. We've gone through what's so-called the height of inflated expectations in the Gartner hype cycle. Now some actually really interesting work is happening under the hoods there, and I expect this technology to be really, really important. And as a result, it's going to basically always have these questions from a legal standpoint, but also from an accounting and an economic standpoint, which I think is really Good. So with that, we're out of time, and I'll just really like to thank everyone who's participated. It went relatively smoothly, and thanks for attending. Greatly appreciated. And with that, I will end it and say goodbye and stay safe. Bye, everyone.
Ka kite.
Ka kite.
Bye-bye.